I'm really learning a lot in these discussions. There are a lot of things that I would like to ask even more. Like, will there be a simple list of things that I need to gather for a specific, for example, is it gonna be for every estate or for every property? Is it gonna be the same set of documents? And what are those specifically that I need to gather? Because aside from the title, other supporting documents that might be needed. Is it gonna be different for every type of property or asset that my parents have owned in the past before they pass?
There are general similarities. I mean, the basic process to keep in mind is you identify the documents. I mean, I'm sorry, you identify the assets, you identify the properties involved. So that tends to go into finding what real estate there is, what bank accounts are involved, perhaps what shares of stock, and then you need to submit the requirements to show that the obligations on these items have been paid so that the transfer of the title can be done. So the list of requirements tends to be, they tend to come from the BIR and the Registry of Deeds. First and foremost is having identified the properties, you should have the original documents of the original titles. Oh, I mean, sorry, let me clarify that. You should have the owner's copy of the titles. You should have updated the real property taxes. So the tax declaration, the annual fees for taxes have to be up to date. There should be no arrears. The Bureau of Internal Revenue will want to know that when you settle the estate, you have identified, you have shown that the scope of the estate is complete. Like the estate you're settling is actually, you've established that these are really all the properties of the parents. So you need to show proof from the local government that the in their records, the titles, the properties owned by the parents are limited to these. So you get a certificate from the local government saying that in this municipality, in this province, these are the properties owned by the parents. And so when the BIR will look at this, they can see that you're addressing all of these properties already. There are other documents, but those are the ones which you need to keep in mind. And well, sorry, you certainly have to show proof that you're actually, the relationship is actually what you say it is. So that the of course the death certificate of the parents, the birth certificates of the people involved, the perhaps the marriage certificate of the parents, to show, to establish that the heir is in fact an heir.
Aside from
Oh, before I leave this, the to find out exactly what documents really need to be submitted, you should always check with the government offices involved, because sometimes they'll add or they'll specify additional documents that you'll need. So they tend to have checklists, but those are the general ones.
is there a site, attorney, where I can, like, for example, if I go to BIR's website or other government agencies that I have to check in to find these documents?
Yes, BIR the BIR has a checklist. In fact,
Okay.
when you go to the BIR to pay the estate taxes, the form already includes within in it a checklist of documents that they're going to look for. So you go through that checklist. You go, and it's similar as well at the Registry of Deeds. These agencies have been doing this for a long time, so they're very developed in terms of their itemization.
So, attorney, the transfer of the property happens mainly or is mainly done with the registry of deeds. Is that correct?
For title properties, yes. For bank accounts, for example, let's say there's a significant amount of money that was in the bank at the time of the parent's death. The banks are supposed to freeze those accounts, or they were supposed to freeze those accounts and insist on the settlement of the estate before they will release the deposit to an heir. With the recent change in the law, the same law which created the estate tax amnesties, the banks are now authorized to release the deposits as long as the 6% estate tax on the amounts in the banks are retained by the bank for the BIR. Although this is a bit theoretical in the case of a lot of banks, because the banks will still insist actually that you settle the estate of the deceased. So you still need to show essentially proof of the deed of sole adjudication or the extrajudicial settlement and a lot of other paperwork before they'll actually release it. But in principle, they're supposed to be able to release to you the amount as long as they withhold, as long as they retain 6%, which is going to be payable to the BIR.
Right. So, if I'm able to collect all of these documents now that I have them, and maybe is there an application form for these transfers, or is it different from BAR, or is it different from the banks and also, for example, the registry of deeds?
Well, so the question is there a form that you submit to these government agencies? Well, the first thing is the deed of sole adjudication. That in itself, it's a formal document that you have to make, or you have to make with the help of a lawyer. It's a sworn statement where you say that the deceased or the parent died without a will, has no longer has any outstanding debts, list the properties, and then you say that you therefore adjudicate, you allot the property to yourself. You have this notarized, and then you bring this to the BIR along with the titles, the updated documents, and then you pay the estate tax by filling out the correct BIR form. The BIR is going to the BIR will have first made an assessment on what the estate tax you're supposed to pay is. So essentially, you go to the BIR, you discuss with them with the scope of the estate. They will make an evaluation of what the estate is worth, what the different properties are worth, and then they're going to come to you with a figure that's supposed to be payable, in which has to be paid before the estate can be transferred. So this amount is assessed, and then it has to be paid, and the correct BIR forms need to be filled out in doing this. And once you do this, and then you have the receipt of having made the payment of the estate tax, the BIR will issue the certificate authorizing registration. Now, this certificate, along with the other documents that you have that you previously showed the BIR, you can now bring to the Register of Deeds. And their Register of Deeds can then effect the transfer. Because the Register of Deeds will not do this without you having showed proof of payment to the BIR.
So, attorney, will I be needing a lawyer to help me with all of these, or is this something that I can do on my own, or with or if with the child and the guardian?
Uh, it's called an extrajudicial settlement in the case of there being more than one heir, or a deed of sole adjudication if there's only one heir. So you don't need to go to court for this as long as the all the heirs are in agreement. So in that respect, you might not need a lawyer, but as a practical matter, it's helpful to navigate this in order to, especially if certain documents are missing or certain documents need to be found, need to be updated. In principle, this is supposed to be something that you can do yourself or a person can do themselves. But in practice, there's a lot to navigate because this is not one of those things that people really are prepared for a lot of the time. So they should have some help. At least they should have the help of somebody who knows how to navigate this and what to do and what to put together and to make sure all the requirements are complete and all the obligations are fulfilled.
Right. So, attorney, that's actually very helpful, and it's good to know that the process is actually very easy to follow. And even though there are a lot of steps,
Well,
it's very understandable.
it's a simplified explanation of what goes on. What it actually involves is a lot of legwork, a lot of transacting with different government agencies, a lot of preparation of documents, uh, a lot of investigation in the case of incomplete records. So it's supposed to be easy to follow, but it takes a lot of actual work. So
Right.
you have to be prepared to that it will take time and it will take a lot of effort to do.
Um, so, attorney, what if the sole child is out of the country and has to settle this? Can that person settle this remotely, or what can that person do in order to settle or handle these things if they are not in the province, or in the country?
Well, the investigation has to happen. At least you need to find out what the assets, the estate is. You need to find out what the documents are that need to be updated. So somebody has to go around these government offices, local governments, the different uh, cities or municipalities, perhaps, to get all of this done. You can empower someone to do that on your behalf. You can also execute the deed of sole adjudication from overseas by having it notarized overseas. We You can have it notarized at the Philippine consulate, or you can have it notarized before a foreign government and have it certified or authenticated so that it can be valid here in the Philippines through the apostille process. But that's another topic. But essentially, you can draft the documents from overseas, and then you can empower somebody to carry them out, to implement them here in the Philippines. So you need not be in the Philippines as long as there's somebody you trust who can go around and get this done for you.
Oh, okay. Understood. So, if this is already in process, would you know what actually happens inside the BIR, or the land registry or city hall when this is processed?
Well, when you present your documents to the BIR, for example, you state that there's a certain property which is part of the estate, and the BIR will make an assessment of the value of this property. So they have a schedule of the values of different properties all over the Philippines. The Commissioner on Internal Revenue, you can check their website, and there's a valuation there of a property in a certain barangay, on a certain street in this barangay. They say that this is the value of the houses there, the land in that area. So they have a schedule that they consult in determining what to what what the 6% tax to impose is. The local assessors and the local governments also may have their own assessment of what the value is. So the rule is that whichever assessment is higher is the one that's going to be subject to the 6% tax. So what the BIR is really going to do is going to look at the completeness of your documents. If they're complete, it can make the assessment on the estate. So there's a process of valuation, and then you're told this is the amount, and you're supposed to make the payment out of for 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 the tax that is imposed. It's important to know that the tax on an estate should be paid within a year of the death of the deceased. If you don't pay it within a year, it will be subject to surcharges and penalties, which are substantial, 25%. And then there's also an annual interest that will be imposed on the estate tax for as long as it's not paid. So so that's what goes on.
How long does it usually take for all of these, like on a normal basis? Does it take weeks or months or even years to settle transfers?
The assumption is that everything is in order. The assumption is that
Right.
this is a single heir, so there's no disagreement, there's no quarreling among heirs on what is to be done with the assets of the properties. So it's simply a matter of putting all the documents together, bringing them, and then making the payment. Um,
Mm.
Usually, it's a process that could take months, but the pandemic has really affected the how long this can take because of
Right.
the closures and the lockdowns and the slowdowns, the skeleton staffing of the government. So it's for this reason, in fact, that the government extended the estate amnesty tax be- by another 2 years because a lot of people who were trying to do this, who were trying to settle the estates of their families, were not able to travel, were not able to go to different government offices. And so the government, because they want these properties to be freed, they want the estate tax because this is revenue that the government needs, especially at this time. They extended the time for people to avail of the amnesty another 2 years. So that indicates to you how long potentially something like this can take.
Oh, okay. Understood. Attorney, what do you think is the biggest challenge for most of your clients when they do process these things? Or what hinders them the most? Or do they have, I mean, based from your experience, if they have hesitations, the things that scare the people normally in processing the transfers?
There are a lot of stages where there can be obstacles. First of all, uh, many of the properties involve more than one generation of estates that has to be settled. So before the estate tax amnesty was there, that was really a big obstacle. It's still an obstacle now, but it's not so unmanageable. The other is that the more relatives there are, the greater the potential for disagreement. An extrajudicial settlement of an estate is only possible if the heirs are all in agreement. They have to be in unanimous agreement. So if one of the children, for example, in the case where there's more than one child now, or one of the cousins who are the heirs of the grandparent don't agree, the settlement is not possible, at least not extrajudicially. Extrajudicial means out of court. It means your only option is to go to court and get the court to make a ruling on how the properties are actually should be divided. So that's one. The other is if documents are missing, and that's very common. Documents are missing or they need to be updated. So it can be a mix of disagreement between the heirs or just a matter of simple, well, not simple, but a matter of legwork and logistics, finding these documents, getting them updated so that the government, the BIR, the registries of deeds will accept them and then allow the settlement.
Right. Wow. Thank you so much for explaining that part, because I think there are a lot of people who need help on creating or starting processing the transfer. And I know that there are people who have literally no idea on where to start on these issues. So I would like to thank you for sharing all these things that we have talked about today. And lastly, I want to ask that is this gonna be very different for when the number of heirs increase, or is it going to be a little bit still the same, or just a little bit of a difference?
Well, the extrajudicial settlement or is the extrajudicial settlement is the equivalent of a deed of sole adjudication.
Mhm.
Deed of sole adjudication if there's one heir. Extrajudicial settlement is if there's more than one heir. They're essentially the same except for that. But again, what you need to have is agreement between the heirs, and also you need to get all of them involved. So there's a challenge if there are many heirs and they are scattered all over the country or the world. You need to get them all to sign off on the agreement, or at the very least empower someone to sign off on their behalf.
I think we can talk about that topic in our next video. So thank you so much for sharing everything today. I really learned a lot.